TikTok's China-based parent company has until January 19th to divest the social media app or face a ban in the U.S. That's unless the Supreme Court or President-elect Trump intervenes. Now, here to discuss what's next, we want to bring in Colin Costello. He's Freshfield's CFIUS and National Security Advisor. Colin, it's great to have you. And when we talk about what is next, I think the big question looming right now is the January 19th deadline. Obviously, that is the day before President-elect Trump takes office. In terms of what investors or maybe what the American public should be considering here, just in terms of the likely next steps, how do you see this progressing up until the 19th and then beyond once the Trump administration is in the White House?
Well, certainly TikTok and ByteDance have already announced that they plan to appeal this to the Supreme Court, and the court could, at least in theory, get this on a docket pretty quickly and review it. The question is really, will they grant a writ of certiorari in the first instance? And there's questions about whether or not they would even have much to review. The Circuit Court here was pretty definitive in terms of its ruling. It didn't leave a great deal of ambiguity. Its ruling that this law passes muster under strict scrutiny, the highest level of scrutiny, when you're talking about a First Amendment case. It ruled that the government has a compelling national security interest and the law is appropriately narrowly tailored, and it's a unanimous decision. So it really, of the things that the Supreme Court could review here, it's pretty limited. It's not going to be a matter of discussion whether or not the correct standard was applied. And of course, the standard of review in these types of cases is something that constitutional lawyers fret over a great deal, and the public, I think, probably doesn't care very much about. But they did apply the highest standard, so it's not going to be a subject of discussion. And TikTok, in their press release, says that the Supreme Court has a long history of upholding the First Amendment. And of course, that's very true. Even in the current composition of the court, this is sort of an area where there is pretty much unanimous agreement among the justices. But I think that TikTok may be overestimating the extent to which that unanimity might play out in a case like this, right, where the issue is national security.
And this morning, ByteDance and TikTok asked an appeals court to temporarily block that law that would require the divestiture here. I just want to ask the question on consumers' minds. How likely is it that TikTok is not going to be available in the United States come January 20th?
So the question then becomes, what do you mean by not available? Because obviously how the law is going to be implemented is it's going to be implemented through service providers like the App Store, like the Google Play Store, who aren't going to be able to, say, push updates or allow further downloads. So it isn't going to be the case that on the 19th or 20th, rather, everyone who has TikTok, all 130 plus million people, that app is just going to vanish from their phones. It's going to be a matter of what happens when updates need to be pushed, what happens when patches need to be released, and that can no longer be done through the App Store or Google Play Store, for instance, because I think out of an abundance of caution, certainly, no matter what the result is with respect to the Trump administration coming in and perhaps even saying that they're going to avoid or delay enforcement of the law, it would seem prudent on the behalf of companies to probably act as if this law is going to remain in effect and indeed start to enforce the quote ban via removing it from their services.
I want to play Yahoo Finance executive editor Brian Sozzi. He had a chance to sit down with Project Liberty founder Frank McCord. He had recently advanced a bid here to buy the social media site TikTok. Here's what he had to say just about the potential path forward here and his interest within the company.
Let's see if we can find a way here to make this a win-win-win, where the U.S. TikTok is split off from ByteDance. China gets compensated for that. U.S. citizens are no longer have their data scraped and have information, quote unquote, spread to them, which may or may not be accurate. And Americans can be protected, and the U.S. government can fulfill its duty to protect American citizens.
Colin, is that win-win-win scenario, is that likely? Is it realistic?
So it might be necessary. Now, what TikTok has been doing for the better part of several years now, ever since the initial CFIUS order in August of 2020 from President Trump, ordering the divestiture is they have been working with the Biden administration to develop a national security agreement. And this agreement's discussed in the court decision, which is unique because typically these agreements are quite confidential. But what you see is that what they're trying to do is a construct where they effectively have a separate U.S. entity from an IT perspective. They have a tiered system of data protection, and they have a trusted third party managing the data and reviewing the code. Well, that's going to obviously, to the extent this law magically goes away, and they just continue to exist under ByteDance ownership pursuant to a CFIUS mitigation agreement, is going to basically treat TikTok US separately, but it could also be equally applicable to an eventual sale and spinoff, if indeed that's the direction they're going in, because notwithstanding the fact that this apparently hasn't been accepted by the Biden administration, CFIUS, they are nonetheless implementing certain aspects of it already proactively. So those things that they are already implementing could lay the groundwork for a future spinoff, which of course ByteDance has already said it has no intention of doing.
And it's interesting because this particular law targets and is focused on TikTok and ByteDance specifically, but you know that this is part of a broader national security concern for foreign involvement here. Can you talk to me about what legislation could look like moving forward that might be a little bit more of a broad approach to data security versus kind of a whack-a-mole approach to individual platforms?
Right. I mean, so what we've seen over the past 5-6 years now is that there are a variety of government authorities that have been used to address this issue of data and availability of data via apps, via the internet to foreign adversaries. And one of the major ones is obviously CFIUS, but we've also seen executive orders promulgated now on protecting American data. And what it looks like from an outsider is sort of trying to catch wind in a sieve, right? Because you're talking about trying to control the flow of data online. And in the absence of a broader framework, sort of like a US GDPR, you're going to ultimately always be in a reactive mode. You're always going to be doing this whack-a-mole approach. But, proponents of that approach might say, that's not a bad thing necessarily. A US GDPR would create a significant regulatory burden for everyone, whereas this particular approach is more narrowly tailored, and it's going to allow us to address the risks where they crop up. So I'm not sure if I see any sort of generalized appetite for a GDPR-style law in the United States, so long as this system that they have implemented and the authorities that they're bringing online appear capable of addressing specific threats.
All right, Colin, we got to leave it there. Thanks so much for joining us this morning.
My pleasure. Thank you.